The next case to come before the court is Kim Okolish v. Town Money Saver, Inc. et al. Each party will have 15 minutes to present their arguments, and you don't have to rush. I'll give you time to get settled there. The appellant may reserve up to 5 minutes for rebuttal. Please let me know if you do plan to reserve time, because I'll be keeping track of time. You may notice that we're having a little electronic problem over there, so you won't be able to monitor the clock below. Obviously, the ordinary clock is moving right along, but I will let you know if you do reserve time when you're getting into that rebuttal time. And the arguments are being recorded, so please keep yourselves behind that podium with your voices up. And please don't use the names of children or victims or minors, should that be the case in this case. You can refer to people by initials or terms like the child. The judges have read your briefs and are ready to proceed when you are. And I would just ask counsel at this time, would you like to reserve time for rebuttal?
I would, thank you, Your Honor.
And how much time would you like?
5 minutes.
Very well, then you may proceed when you are ready. And also, please introduce yourselves.
Oh, thank you. We all set, ready to go?
We are.
Good morning, Your Honors. May it please the court, my name is Roy Schechter, and I'm here on behalf of the appellants Town Money Saver Incorporated, or I'll just call Town Money Saver, and TMS Franchising Inc. They are the appellants in this matter. And thank you, we've already reserved 5 minutes for rebuttal. As I think I'll be able to explain, as you said, you've read the briefs, and I appreciate that. I'm just going to highlight some of the important issues that I think will have you finding that the trial court got this one wrong. I think they just got this one wrong. This is an arbitration clause contained separately in a franchise agreement between two sophisticated business entities. Town Money Saver operates a advertising sales coupon business in multi-territories around this part of Ohio. Perhaps you've seen them, where you go out and sell advertising. They then print up coupons, mail them out. People use them, and they get payment for doing that. And they've been in that business for about 25 years. Kim Okolish is also in the same business, and she was in that business for many years before she ever met Town Money Saver and their CEO, Bill Zerzo. And after some discussion and negotiation among the two of them, she decided, hey, I'd like to run my business as a Town Money Saver representative. At that point, there was no franchising, there were no franchisees. She just continued to do essentially what she had been doing, a sophisticated multi-district advertising sales business, selling advertising to many individual businesses under the Town Money Saver's name. And as I'll explain here, I think that's really critical to remember, because she could have continued operating as a representative and never become a franchisee. To this day, there was never any requirement that any representative become a franchisee, and there are numerous instances, and the only evidence in the record is that she was never given any ultimatums, threatened, coerced to become a franchisee. And there are many other similarly situated representatives who were operating as representatives for Town Money Saver at the time Kim Okolish began doing that, and did it for about 8 years, and are still doing it today. They just decided, hey, I didn't want to become a franchisee, no problem, no big deal, and they are still doing it today. Kim Okolish could have done the same. And I think we'll see that one of the primary findings of the court was that there was some kind of ultimatum given to her that she had to enter into the franchise agreement that had that arbitration clause, or forfeit her business and marketing area. There's absolutely no evidence in the record to support that. And in fact, there's a lot of evidence to the contrary. We're dealing with a arbitration clause. I'm not going to recite the law thing. I'm sure you've heard it many times, that except for the part they're favored, they save time, money, much more easy and condensed way to resolve a dispute than going through the entire litigation process. It saves everybody money in the long run. The attorney fees can become exceptional. And if you're going to challenge the enforcement of an arbitration clause, in this case, the appellee, Ms. Okolish, was required to show it was both substantively and procedurally unconscionable. And I think the evidence before the court is that she did neither. I'm not sure what happened between the hearing that we had on the motion to enforce the arbitration provision, and it took a year for a decision to be issued. I'm not sure what happened during that interim period, but I think the court kind of lost their way and maybe wasn't able to follow the evidence that was presented at the hearing, as well as the documents that would have shown that there was the arbitration clause was not unconscionable, either procedurally or substantively. As I said, Ms. Okolish was operating this business for 8 years before she ever met Mr. Zurzo, or for many years before she met Zurzo. Then she continued as a town money saver representative in multi-districts for 3 years after being presented with the franchise agreement containing the arbitration clause. She continued doing her business for 3 years in just the same way before she decided, hey, I think maybe I would like to become a town money saver franchisee. She thought it might offer her some benefits. There are certain benefits that are provided in the franchise agreement. And after 3 years, this is not a situation where there's any time pressure involved, where it was going to affect her in any way. She just decided, hey, I think I would be able to move forward better with town money saver as a franchisee than just being a representative. And when she was questioned about this at the hearing, first she testified, I didn't read through the contract before I signed it. For whatever reason, she didn't read through the contract. That is a quote unquote from her testimony. And there's quite a bit of law from the 9th District and other districts that if a party doesn't read an arbitration clause, it can't be found to be unconscionable, and it's going to be enforced. So why she didn't read it, I don't know, but that's what she testified to. And then she said, I felt I had no choice but to sign it, or I wasn't going to be able to move forward with town money saver. She said, I wasn't going to be able to do as well as I would have liked. I think I would give me more opportunities. And she did not testify, and there is no testimony in the record that anyone ever told her, gave her an ultimatum that said you either sign a franchise agreement or you forfeit your business and marketing area. And that's what the trial court said. I said I almost fell off my chair when I read that, because I read through the record carefully. I handled the hearing. I know what the evidence was. There was nothing like that. And it said, based on the foregoing, the court finds the arbitration provision as contained within the franchise agreement is procedurally unconscionable. So I would submit that if you don't find any evidence that anyone ever gave her an ultimatum, forced her to go ahead and become a franchisee, and that there was nothing in the evidence that she had to forfeit any of her marketing area, then I think that the trial court simply lost its way, and the arbitration provision is not procedurally unconscionable. They also had the obligation to show that it was substantively unconscionable, and I think they failed to do that as well. The parties really, in this case, were of equal bargaining power. Ms. Okolish could have become a franchisee if she wanted to. She could have not become a franchisee if she didn't want to. Many other similarly situated representatives have continued since she first began through the present, and they are not franchisees. It hasn't hurt their business. They've been able to sell advertising through multi-district territories without any issue whatsoever. So this isn't a situation where there's unequal bargaining power here. It was simply up to her if she wanted to do this. Even to this day, nobody has to be a town money saver franchisee in order to sell town money saver advertising. The court also focused in on the substantive unconscionability aspect as to the cost of filing an arbitration. Well, there is a cost to file an arbitration, and it's dependent on the amount of damages that you're seeking. I would submit that the amount of damages that are being sought, which are $800,000, and attorney fees and punitive damages almost $1 million. It is so out of bounds that it's hard to believe that it's even being fled. During the last few years that she operated in her territories, she was not doing well. A lot of the territories were losing money. She was not making a profit. This whole dispute arose because she wound up running up $132,000 in printing costs for Town Money Saver, printing up her coupons. And when she was contacted, hey, would you like to pay? And in fact, these people were friends. They got along for years. They would go to each other's family events. Town Money Saver and Mr. Zerzo would testify that they were friends. They liked each other. They did many things to help her, including allowing her to continue operating this business even though they owed her a lot of money. It wasn't until she was contacted, hey, what can we do about paying this $132,000 that you owe, that she found an attorney. And what happened is she won the race to the courthouse, and she filed a lawsuit seeking almost $1 million in damages. Well, when you do that, if you have an arbitration clause, you're going to have to pay whatever the filing fee is for a number that's involved. Town Money Saver would have to file an arbitration fee as well for the counterclaim, but it's really the basis of the fact that she's seeking such high damages in respect to anything that I think could even reasonably be demonstrated by the evidence, that she's talking even about the cost to file. But that's not all. There's all the attorney fees that are involved. And I don't know what the nature of her relationship is with her attorney. I know my client's paying a lot of money to be represented and pay attorney fees in court. And I know through doing this for 30 plus years that if you wind up going through litigation and depositions and written discovery and experts, it's going to be a huge amount of attorney fees. And arbitrations can be much more condensed, concise, cost-friendly way of resolving disputes, and that's why they exist, that's why they're preferred, and that's why they should be enforced whenever possible. Here, there was the only evidence that was put on by Ms. Okolish as far as these costs were was the filing fee chart related to AAA. There was no mention of what the attorney fees were, and there was no comparison to what the cost of arbitration was versus the cost of litigation, which is the burden of somebody who's trying to find it substantively unconscionable on the basis of the expense. I think that it's very safe to say that the costs in attorney fees and everything else involved with litigation in court are going to exceed greatly what they would be through going through an arbitration provision. It's also interesting to note, and the court's opinion even notes this, that the arbitration clause, it applies equally to both parties. It's not skewed towards one or the other. And it also says that the prevailing party will be awarded their costs and their fees. So if she wins, she's not going to wind up paying anything. So, the fact that she wants to file an arbitration for what I consider to be an outrageously high amount, and that would cost some money, well, that's part of what she signed on for. Whether she read that arbitration provision or the contract or not, she testified she didn't. But there's going to be a cost to do that. There was no comparison. There's a number of cases that were cited in my briefs that she has the obligation of showing that the cost of arbitration would substantially exceed litigation, and she didn't do that. That wasn't a part of the evidence. So I would submit, I don't know where we are in fact here.
Counsel, you're actually moved into your rebuttal time, so.
Okay, well, I would just submit that the trial court got this wrong. The arbitration provision was not substantively or procedurally unconscionable. I ask you to remand it to the court with instructions that they compel arbitration.
Thank you very much. You may proceed when you're ready.
Thank you. May it please the court, my name is Dan Orlando. I represent the appellee, Kim Okolish, in this appeal. There are a few items that Attorney Schechter brought up that I think I would like to address directly, and then I'll go over some of the finer points of the brief that we submitted. And again, I appreciate that you read the brief, and I'm not going to go through a big factual background or anything like that, but there were a few points right off the bat that I wanted to address that were brought up in opposing counsel's argument. The first being that these were two sophisticated parties, sophisticated businessmen basically, And that really is not the truth. It was a year before Ms. Okolish met Mr. Zerzo that she started this Town Money Saver coupon clipping business, where she really just printed up coupon clipping books and sold them door to door, kind of what you're envisioning, what you see in your mail. A year later, she was actually approached by Mr. Zerzo about partnering up with him. The idea being that he would be essentially be the broker for her, so that he could go to her, or she could go to him, I'm sorry, and then he would facilitate the printing of these booklets and then give them back to her. He would take a commission for brokering it essentially, and then she could go out and continue selling in the community. At the point in time that she signed this franchise agreement, she was not some multi-state business mogul. She's just selling these door to door in Canal Fulton and Canton. She's got some clients, you know, she makes a few bucks on it. It's not exactly a fair representation to say that she was very sophisticated in this regard. And I'll get to more detail on that as we get to the procedural unconscionability. But also the idea that she was not required to become a franchisee, obviously that is what's at dispute in this lawsuit. So I don't think that this is really the appropriate forum to have us make a determination as to whether or not she was given this ultimatum to either sign on to the franchising arrangement with TMS Franchising or forfeit the name Town Money Saver that she had been building up this little business that she had under. And obviously her testimony at the hearing that we had on this matter at the trial court was that she was given an ultimatum. She had been working with Town Money Saver for several years, running ads underneath the name Town Money Saver. At some point, Mr. Zerzo opened up TMS Franchising Incorporated, and at a certain point, he came to her and he essentially said, this is it. Either you sign on as a franchisee, or I'm cutting you off. You're not going to be able to use the name Town Money Saver anymore. You're not going to be able to open new territories. You're not going to be able to start new business. You can't continue doing this. And that's her testimony as to why she entered into this arrangement. And that also reminds me that I would like to mention that, you know, the standard of review, which is very important in this case, is obviously it's de novo. We're dealing with a de novo review, but the Ohio Supreme Court in Taylor Building Corporation of America versus Benfield was explicit in noting that, quote, we hold that the proper standard of review of a determination of whether the arbitration agreement is enforceable in light of a claim of unconscionability is de novo, but any factual findings of the trial court must be accorded appropriate deference. And in the court's order that was issued on this matter after what was held was about a several hour-long hearing where there's an 80-plus page transcript on the matter, the court did say that finally Ms. Okolish testified convincingly that given her economic position, she felt as if she had no choice but to enter into the franchise agreement when she did. So I think that those are some important high points to note to the court. Now, getting into the procedural unconscionability argument, I know opposing counsel brought up this issue of whether or not she read the agreement. There's 2 points that I'd like to bring up on that. The first being that she did in fact read the agreement, and that was an issue that was decided at this hearing. And we actually have transcript testimony. I'm sure that you saw it in the briefs. I believe the provision that opposing counsel was referring to was an exchange between opposing counsel and Ms. Okolish, where he asked, you recall reviewing this contract before you signed it, the franchise agreement, and she answered, I didn't read through the contract before I signed it. I felt at the time I had no choice but to sign it, or I wasn't going to be able to move forward with Town Money Saver. Now, it's important, obviously, that we were at a live hearing, and, you know, voice inflection, context, all these things are important. It was never brought up again that she did not sign this agreement, and in fact, or I'm sorry, that she did not read the agreement before signing it. And in fact, literally moments later, you know, further down on the exact same page of the transcript was the next interaction, again between opposing counsel and Ms. Okolish, where opposing counsel asked, okay, and you would agree that the second to last provision in its own separate section, in all capitals, the section's called arbitration. Did you ever review that provision as you read through the franchise agreement before you signed it? And Ms. Okolish answered, I read the whole franchise agreement where I signed it. At this point, I guess there were things in the contract that I definitely should have hired an attorney and had them read it, but I did not do that. So she cleared up the record, I mean, moments later. Obviously, she didn't mean to say that she didn't read the agreement. Now, regardless, though, I think it's important to note that there is not an explicit factor, which I think is sort of how it was portrayed in the briefing and here at the argument, that there's a specific factor that says if the party did not read the agreement, they cannot bring up a claim for unconscionability. And nowhere in the case law is there actually a definitive answer that's that pointed. And in reality, there's actually the factors that are brought up by courts, that, by the courts in this district, to determine whether or not an arbitration provision is unconscionable, procedurally unconscionable, are the age of the parties, the education and intelligence level, the business acumen, experience in similar transactions, whether the terms were explained to the weaker party, who drafted the contract, and whether the weaker party was represented by counsel. And nowhere in those factors did the weaker party read the agreement. And in fact, I believe that having whether the terms were explained to the weaker party sort of implies that there are times where it doesn't matter if the weaker party read the agreement or not, because they weren't going to be able to understand it anyway, and they needed professional help to assist them with that. And in fact, I think that it's telling that during that same hearing, that was, again, multi-hours long, both witnesses were there, Mr. Zurzo actually testified that the agreement that Ms. Okolish signed, which was a 59-page franchise agreement, was full of legalese. That was his testimony. And he said that he needed an attorney to explain to him what it all meant and to explain to him what the arbitration provision meant. So he's really trying to hold her to a standard higher than him.
Well, he hired an attorney.
Yes.
She had the option to hire an attorney, correct? And testified that she should have.
Yes, Your Honor. Of course, she had the opportunity to hire an attorney. However, I would argue that her sophistication level, she was a high school educated person. She had no legal experience at all. Her business experience was really relegated to just selling these magazines around the community. And the contract experience that she had leading up to this was just a one-page term sheet that she gave to people who bought magazines from her. And she actually testified at the hearing that a lot of times that one-page term sheet went away and it just became a handshake deal. So I don't think she really appreciated the importance of having an attorney to represent her.
Well, when we talk about procedural unconscionability, and we use the word ultimatum, in most cases there's a lack of a choice to, a clear choice to do anything before that document needs to be signed, right? Most cases, and just not substantive, but procedural unconscionability. Many times there's a health-related issue. What's in this record for the finding that she did not have the opportunity to seek assistance regarding the franchise agreement?
Well, Your Honor, I believe that the duress didn't exactly go to her inability to seek counsel. When she testified at the hearing, the way that she explained it was, she said, I didn't even bother seeking counsel because I knew that I had to sign this agreement one way or another. So it wasn't a matter of that he was saying, you can't leave this room until you sign this agreement, you can't talk to an attorney. It was really more of a matter of, well, I'm going to sign it anyway. I have to if I want to continue to run my business. So what good is it going to do for me to hire an attorney and spend all this money when I'm just going to come right back and sign it anyway? And that was sort of her thought process, again, as an uneducated person, a high school graduate. But I don't think she really appreciated the necessity of having an attorney to review this document for her at that time.
What is in the record, counsel, that made her have to sign it?
Your Honor, I don't have all of the quotes with me, but in the hearing, I believe that there was I actually think that there was in that provision that I read to you earlier, where she said, I felt at the time that I had no choice but to sign it, or I wasn't going to be able to move forward with town money saver.
Can you expand, but is there anything in the record that underpins that she came to that conclusion?
Well, Your Honor, that's sort of the basis of the case that we're filing, because part of what we're arguing is that there are two entities. There's Town Money Saver and then there's TMS Franchising. Town Money Saver was the entity that she had been dealing with since 1997, I believe, which was one of Mr. Zurzo's business entities. That was the entity where she was partnered with it. She would give it money, and the entity would go and broker these printing services. And that was the entity that really gave her the permission to use the name Town Money Saver in the beginning. And then as we got to 2007, I believe was the year, 2008, I believe was the year, that was the year that Mr. Zurzo then shows up with this other entity, TMS Franchising, and says, either you sign on with TMS Franchising as a formal franchisee, or I'm cutting you off from Town Money Saver, there's no more utilizing that name. So that's why we kind of have these mirroring claims between two entities that are moving forward.
Does the complaint then have in it a claim by Ms. Okolish about a breach of the agreement, the franchise agreement?
It does, Your Honor. It has one claim for breach of contract against TMS Franchising because again, we didn't go over this. Part of the issue is later, TMS Franchising actually gave away her act. She had a few territories that actually were making.
So she's utilizing the agreement in the claim, in the merit-based claims, to say I was harmed because the other side, whether it's who it is not an issue for me right now. The other side breached this agreement that I signed.
Well, Your Honor, it's a little bit, respectfully, it's a little bit more complicated than that, just because there's the one entity that, yes, that's exactly what it is. TMS Franchising, it's, you breached the agreement with us, and, we think that by giving away these territories without stepping in the way that you're contractually obligated to do it, that you violated the agreement. Now, the conduct with Town Money Saver, which was essentially, Town Money Saver was the entity that was giving her the ability to utilize the name Town Money Saver. And that entity came to her and said, hey, either sign on with my affiliate or I'm cutting off the name. You're not able to use it anymore.
That's in the record?
I believe so, Your Honor. I believe that was in the hearing transcript.
Or at least alleged in the complaint?
It was, and to be honest with you, I don't know if the complaint needs to be amended or anything like that. I'm not sure what it reads at this point. The complaint was filed several years ago, and it was almost immediate. In fact, I don't think there's even been an answer filed in this case. It was immediate that it ended up going through the arbitration process. Now, going to the substantive unconscionability argument, there actually is case law that says that if the terms are so one-sided as to oppress or unfairly surprise a party, an arbitration provision can be substantively unconscionable, and Ohio courts have interpreted the undisclosed, excessive, and prohibitive costs on the claimant to be substantively unconscionable. And it is important to note that this specific issue of prohibitive costs was brought up at the hearing. The idea that Ms. Okolish, this was her sole source of income. She's an upper middle-aged woman, so she's looking to retire at this point. And what she was hoping to do was to sell the territories, the ones that actually made money, the ones that she had built up that made money, and utilize those funds to retire. So she doesn't have the wherewithal to continue on, funding a case like this, especially in arbitration where, as the testimony did show in the hearing, the filing fees alone would be over $12,000 for this case, plus the costs for the arbitrator between $5,000 and $10,000, plus the cost to have her attorneys litigate this dispute.
Does the arbitration clause require you to use the AAA?
It does, Your Honor. And importantly, one thing that I think that should be noted is that there's this case law, I believe, that was cited by opposing counsel that was Norman versus Schumacher Homes of Circleville. I believe that was the one where they said that the inability to show that the cost of arbitration substantially outweighs the cost of litigation can preclude a party from showing substantive unconscionability for an arbitration provision. But it's important to note in that case, one of the distinguishing factors was that, one of the biggest distinguishing factors was that in that case, the litigant had not actually filed a claim for damages at that point. The litigant had only filed for a declaratory judgment action, and it was only after the litigant made the argument that the arbitration provision was substantively unconscionable that they went back and said, well, we would be seeking, over $1 million in damages, and, so it's going to end up being way too expensive to go after this party. And the court said, well, you're talking about a dispute over a house that's worth $140,000. It seems a little bit far-fetched that you're going to be seeking over $1 million in damages. We think that you're kind of beefing those numbers up to show that you don't want to arbitrate. But in reality, one thing that none of these cases have addressed that I think is very important is that in this case we have two very related entities. We have TMS Franchising, we have Town Money Saver. There's only one contract, and it's between Ms. Okolish and TMS Franchising. There's no contract between Ms. Okolish and Town Money Saver. And the case law is explicit in noting that Ms. Okolish in this circumstance cannot be compelled to arbitrate her claims against Town Money Saver. She can only be compelled potentially, which is why we're here today, to arbitrate her claims against TMS Franchising. So in this case, there's no question that it would be...
Also, I'm going to have to ask you to wrap up.
Oh, yes, Your Honor. My last point, there's no question that it would be more expensive to have to arbitrate in this case, because Ms. Okolish would have to arbitrate her case against TMS Franchising, and then when that case is concluded, she would have to come right back to state court and litigate a very, very similar case against a very, very related party all over again, so the cost would be double. So for these reasons, I would request that this court uphold the decision of the trial court. Thank you, Your Honor.
Thank you, counsel. Counsel, you may proceed with rebuttal. You have about 4 minutes.
Thank you, Your Honors. Here, just quickly, I want to respond to several of those points. The last one doesn't make any sense, okay? They filed a lawsuit seeking joint and several damages against both Town Money Saver Incorporated and Town Money Saver Franchising. They have a claim that the franchise agreement itself is improper, okay? That's subject to the arbitration provision found in the franchise agreement. Then, as all of the franchise agreements say, any dispute arising under the franchise agreement is going to be arbitrated. Well, that's their claims against Town Money Saver. They're claiming that we didn't abide by that very agreement. So I don't even understand why that's been raised. It didn't play any part in the trial court's decision anyway. Factually, Town Money Saver Franchising began in 2005, and everybody who was a representative was presented an opportunity to review the franchise agreement and, if they wanted, become a franchisee. She had 3 years before she decided voluntarily that she wanted to become a franchisee rather than a representative. Others never did, and they continued without any problem. And sure, I understand the concept of de novo review and the fact-finding made by the trial court, but here I encourage the court, and I'm sure they will, to review the transcript and all the evidence. There's absolutely no evidence of any kind, even from Ms. Okolish, that anyone gave her an ultimatum, told her she couldn't continue to do her business, would lose her territories. That simply never happened. That's just kind of was come up with to try to avoid the arbitration provision in response to the motion that I filed. And just with respect to, yeah, she said, I didn't read the franchise agreement. That's clear. When I asked her later, did you read the separate document that was called an acknowledgement clause, where she acknowledged that she had all the time that she wanted to review the agreement with any representative her choosing? She said, yeah, I read it where I signed it. That's right above where she signed it. So that's the only thing that she testified that she read. And the problem that my distinguished opposing counsel mentioned about far-fetched numbers affecting the cost of an arbitration is totally applicable in this situation. But I think as you review the evidence before the court, you're going to find that the franchise agreement and the arbitration clause is not substantively or procedurally unconscionable, and I urge you to return this matter remanded to the trial court with instructions to arbitrate. Thank you so much for your time.
Thank you, counsel. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail you a copy of that decision on the day that it's released, and it will also be posted on the Ohio Supreme Court website. The court is now adjourned.